Ready to begin? Professor Waller, thank you for joining us. I'm Jonathan Silberman. I'm an associate at Weisbrod, Matteis, and Copley. I'm here hosting today's conversation on the political misuse of antitrust. I'm a member of the board of directors of the ACS's DC Chapter, and we are hosting this event with the UCSD School of Law Chapter and the LA Lawyers Chapter. I'd like to present Professor Waller, our speaker, who is the John Paul Stevens Chair in Competition Law at Loyola University Chicago School of Law. We're going to be discussing his recent work in political antitrust. So, Professor Waller, anything you'd like to add, or let's get to it?
Yeah, well, thank you, Jonathan. Thank you, Austin, who's also on this call and handling some of the tech. And thanks to ACS for inviting me to talk about my work on sort of the political face of antitrust and also the political misuse of antitrust. As Jonathan indicated, I teach at Loyola University Chicago. I direct our Institute for Consumer Antitrust Studies, which is a sort of nonpartisan but more progressive institute, and it's the only one of its kind in the United States that looks at competition law and consumer protection. And our mission is to promote a more competitive and consumer-friendly society. So I've been teaching there for 20-some years, and I taught at Brooklyn Law School before that. And I practiced in antitrust and other kinds of commercial litigation. I do not consult in the tech space at all, and that's, I know, something that comes up a lot when people speak on some of these issues. For what it's worth, a few years ago, I was adverse to Microsoft in a class action outside the United States that related to the browser wars here in the United States in the 90s. So I have been following antitrust developments for a long time, and I have watched student interest and general lawyer interest, as well as interest in the real world, kind of wax and wane since I graduated law school in the early Reagan era, essentially. And so, a lot of my work that I'm going to chat about today stems from the fact that I think antitrust is enjoying a renaissance. We're having a moment, as sort of I said in one paper, almost simultaneously, a more conservative professor, a really smart guy named Tom Lambert, sort of started his article exactly the same way. So I think both the right and the left acknowledge that there's something going on, and I want to talk about that. I want to talk about how antitrust has become an important, not the only, and certainly not the most important in the time of COVID, but antitrust issues are a serious part of the political campaign, particularly before the pandemic shut down the economy. And it is part of what a lot of candidates ran on and talked about in the election cycle. And I think equally interesting, it's what people are talking about, both in the general legal profession and as part of sort of the civic discourse. And I think that's generally to the positive, and I'll talk about why. But I also think there is a growing concern that antitrust has been misused by this administration. It's not the first time such allegations have been around. And I want to talk about what those allegations are, how they compare to what's happened when other administrations have tampered with the enforcement of antitrust laws for political purposes, and some of the tools we have to deal with it and what those limitations are. And obviously, I hope we can field some questions. And I know some of you may practice in the antitrust area. Most of you don't, and some of you are in law school, and all that's great. So, we're really talking about the set of laws that regulate market competition. They're the laws that have been around since the 1890s. They are primarily the Sherman Act and the Clayton Act. And the 2-second description is that there are 3 parts of the antitrust stool. One leg prohibits anti-competitive agreements, mostly between competitors. The second leg is the part that prohibits monopolization and attempted monopolization. And the third part of the laws are the Section 7 of the Clayton Act, which prohibits anti-competitive mergers where they're likely to harm competition. So that's the sandbox that we're playing in. So Jonathan, I know this is more in the form of a conversation. I can keep talking as long as you want. I'm happy to answer some of the questions that you and I have talked about preparing for this.
So the first question, I think you started to get into this, is just a little background for those who may be uninitiated in the field of antitrust law or would like to hear better. Just sort of, I'm going to start with our slideshow and tell us a little bit about the history, why it was enacted, and what did we see at the beginning of antitrust?
Sure. So as I started to talk about, excuse me, antitrust at the federal level has been with us since the 1890s with the passage of the Sherman Act. But the concerns really began much earlier. In the follow-up to the Civil War, we had for the first time a national economy with national transportation, national communication system, and a series of boom and bust economy that led to a lot of corporate consolidation. You know, I'm sounding like I'm talking about today, but I'm really talking about the 1870s, 1880s, and 1890s. And the states were the first ones to pass antitrust laws starting around 1880. I believe Kansas was the first state to do so. And there were various state actions to try and tackle the growing national trusts, national monopolies, and merger wave that was coming. Problem is, no one state really has the jurisdiction or the practical power to break up a national corporation. Ohio came the closest, where they dissolved Standard Oil for violating their corporate charter. They reincorporated in New Jersey. So there was a movement to have a federal antitrust law, and the Sherman Act that we've talked about was the a result of all that, and that had the three provisions that I talked about. And in terms of enforcement, it was enforced by the federal government through the Department of Justice, and it could be enforced through treble damage suits by private individuals who've been harmed in some way. In the very beginning, those private suits were a relatively small part of the way the Sherman Act was enforced. Today, private litigation is about 90% of all the cases that are filed.
Going past sort of, we see in the beginning it has some salience as you see people like Ray Roosevelt labeling themselves trust busters and going after some of the big corporations, including, of course, Standard Oil, the Sugar Trust, other trusts. Can you sort of, going forward, we get into sort of the Roaring '20s and the Great Depression. Can you sort of bring us through sort of what you've referred to as the consensus era?
Sure, but if you could, John, if you could just back up for one slide, just so I didn't get a chance to talk about you know, now that we're in a presidential election season, just to imagine the election of 1912 with four candidates, and I'll explain why for folks if they're not familiar with it. But this is an election that largely turned on, and was probably the apex of you know, political antitrust. All four candidates had something to say about antitrust in 1912, and there's a great book called The Election of 1912 by a guy named James Chase that talks about this. But it's just remarkable. Three major candidates and Eugene Debs, who was a socialist. But William Howard Taft was the incumbent, and he basically favored continued enforcement of the Sherman Act through the courts. He thought the rule of reason from the Standard Oil case was workable. Teddy Roosevelt, who preceded Taft, handpicked him and then grew completely disaffected with him, largely about antitrust, ran as a third party. And he was saying that we needed more of a regulatory approach to distinguish between good monopolies and bad monopolies, and that the rule of reason allowed judges just to pretty much apply their political you know, preferences to whether or not a company violated the law. And then as the Democrat, Woodrow Wilson sort of said we needed more specific laws, we needed new institutions to enforce them, and kind of split the difference between Taft and Roosevelt. Eugene Debs was the socialist. He was a labor law leader and was, in fact, I believe, serving time or had just completed serving time for violating an injunction relating to a labor dispute where the antitrust laws had been applied to break a strike, basically. So you had, you know, really a roaring debate about the you know, what the role of antitrust should be in our market economy. And Wilson obviously won. And what happened is you got the Clayton Act with new provisions, and you got the Federal Trade Commission as a new institution and a broader mandate to talk about prohibit unfair methods of competition. So as you were getting to, you know, obviously by the 1920s, several things happened since the election. Obviously, World War I happened. You had the Roaring '20s followed by the Great Depression. And through this era, there's sort of a political consensus. It doesn't mean that antitrust is being enforced as strongly at any given time. It's that the Democrats and the Republicans were sort of in alignment, whether antitrust was kind of going up or going down in terms of how much was you know, going on in the real world. So during World War I, very little of the law was being enforced around a wartime economy. During the 1920s, very little of the law ended up being enforced for a variety of reasons. And the first half of the New Deal, the Great Depression, was so severe that FDR really went into a completely different mode and more or less tried to cartelize industries under the National Recovery Act and these codes that industry would negotiate between themselves with a little bit of labor and a tiny bit of consumer involvement. That approach was, two things happened. One was that the NRA was declared unconstitutional in 1935. And second of all, it didn't work. It was a dumb idea. And it led to even less production and more misery. So in the second half of the New Deal, Roosevelt kind of took a hard turn and decided that market competition was the way to get the country out of the Great Depression. He hired the greatest trust buster in our country's history, Thurman Arnold. Happens to be the Arnold from Arnold and Porter, but no, this was before that. And Thurman Arnold was a law professor at Yale. He was himself sort of a critic of the antitrust laws, but in his 5 years, the longest that anyone has run the antitrust division, he brought more cases than I think anyone had, like in the entire time before that, between 1890 and 1943, when he left to become briefly a judge and then start his law firm. And then this groundswell of enforcement continued through World War II, when after international cartels, oftentimes that had links to Nazi corporations prior to the war. And there was a continued expansion of antitrust enforcement under both Democrats like Truman after Roosevelt died, and Republicans like Eisenhower, and even Kennedy and Johnson and Nixon. The laws are being enforced with sort of a general bipartisan consensus. And what really led to antitrust dropping off the cliff was the rise of the Chicago School of Law and Economics, particularly on the Supreme Court. Lewis Powell was kind of the key person who began to change things in the 70s, and Scalia and the more conservative majorities since that time. But there are also plenty of conservative Democrats. And again, antitrust enforcement dropped a lot in the Reagan years, but it did not rebound anywhere nearly as robustly under Clinton and Obama. Well, did more, but didn't change the fundamentals of what's going on, in part because the Supreme Court was restricting who could sue, what the theories were you could sue on, and how much you needed to prove. So that's a super short history, obviously, of more than 100 years. But that takes us to sort of where we are today, and at least some return of what I've called in two different articles, political antitrust.
And I guess the question then is, what do you mean by political antitrust?
Well, part of what happened from the Reagan administration on is that I think the public and the more democratic institutions of our government, the legislature, began to just leave the field to technocrats. It became very economically oriented, and that by itself is neither good nor bad. But when things get very complicated and you have to do a lot of economic analysis to understand how a case could or will come out, it's not the kind of thing you want to talk about at the breakfast table with your family. And if you're not trained in economics, you may not feel like it's maybe intimidating and in this province of experts. So candidates didn't run on antitrust in any important way for 50 years. The Democrats and the Republicans left antitrust out of their platforms, other than occasionally Republicans would take a shot at it as a form of unnecessary governmental regulation. And I think that's turned, and I think in a good way, the institutions of our country that set our fundamental political economy principles, which is mostly Congress and also the executive branch, are starting to get interested in this topic again. And so the candidates, and you see the leading Democrats from one of the debates, up on the slide, they talked about it. And even the Republicans talked about it. And even Trump had talked about it as a candidate in 2016, and a little bit, again, particularly before the pandemic. And I think it's become part of the political discourse. It's by no means the only issue that people care about. That would be crazy, given the economy and the pandemic and other things. But the candidates talked about it. The New York Times talked about it. TV commentators talked about it. People are writing books that are not designed for experts, but designed for, just generally smart people. I happen to be reading one by a guy named David Diane, which is terrific on the economic and social and human costs of industrial concentration and the growth of monopolies and over mergers and concentrations. So I'm suggesting that it's political in the sense that it's something that people debate about, and rather than entirely leaving to experts, we're starting to have campaign proposals, and we're starting to have some legislation, and we're starting to have some conversation just, as a society about how we can do different with that.
And I guess you fleshed out some of the benefits here, but if you can sort of give me more on sort of what are the costs and benefits of making this a more politically salient issue, I guess?
Yeah, so, if there hasn't been, depending on how you sort of, how you want to classify this, there hasn't been, major antitrust legislation in one way since 1950, where Congress really increased the oomph for the merger laws, made it harder for companies to merge. And then the Supreme Court kind of cut back on that through interpretation. So, it's been just a very long time. There's some legislation in the 70s that's sort of important. It's a very long time since Congress has dug into antitrust in a meaningful and fundamental way. And, when elected officials are having hearings and introducing legislation, and candidates are talking about their proposals. That's what I mean by political antitrust, in the sense of those branches of government are starting to get involved rather than leave it just to the technocrats. Of course, you want honest, smart, technically competent people in the agencies bringing these laws, and smart lawyers litigating them on each side. I'm suggesting we bumped antitrust up a level of controversy and conversation. And I think that's generally a good thing. We're going to get in, I know, a little bit later in the conversation, to some of the bad things. The bad thing, in summary, is this administration, there's more allegations and more reasons for concern that they are looking at bringing cases to punish political opponents, and looking to settle cases or not bring them to help perceived political allies. And I'm not suggesting that this is outright corruption. We can talk about that more. And I'm not even suggesting that all these cases are frivolous that they're working on. But I think we're facing the first time recently, particularly because antitrust laws were not being enforced robustly in many of the decades. We're facing for the first time, we have to talk about whether whether the government's doing the right thing for the wrong reason, or at least for a very substantial part of the wrong reason. So that's what I mean by the costs and the benefits.
So I guess that segues nicely into sort of what are the proposals that we are seeing from, I guess the Democrats had a number of people running for the presidency. So we had a lot of different proposals and a lot of different ways to try and differentiate themselves. So I guess what did we see in the Democrats as they were gearing up for the primary, which for me at least feels like a long time ago, and going and continuing into now the Congress as the election cycle continues?
Yeah, so with the help of one of my students, who is in fact my co-author of the two papers that I talk about this, third year named Jake Morris, terrific student and great to work with on these projects. We just totally antitrust nerded out and just got into as many of the campaign policies and proposals that the Democrats had, and the little bit that Trump talked about these issues as a candidate. And then we can talk about some of the legislation that's pending. But it's interesting, really half a dozen or even slightly more of the Democratic candidates talked about this stuff a lot. And as you can see from the slides, not shockingly, Klobuchar, Warren, and Sanders had the most to say about this. But also, Cory Booker had proposals to deal with banning mergers and vertical integration in the agribusiness space. Pete Buttigieg had some interesting ideas about limiting arbitration clauses that prevent class actions and other kinds of antitrust cases from ever making it into the courts. More than 6 of the candidates were talking about issues relating to big pharma, not just mergers, but so-called pay-for-delay agreements where branded pharmaceuticals keep generic entrants out of the market in different ways. But the 3 big ones were Sanders, who wanted to put just hard caps on mergers, in terms of market size of the participants. So I'm talking about size, not necessarily market share, and more strict enforcement with respect to vertical mergers and horizontal mergers. And both Sanders, Klobuchar, and Warren picked up on some things that are happening outside the United States where our agencies don't have the power to fine companies. Fines and antitrust are only available in criminal cases. So abroad, in Europe and most other jurisdictions that I've been able to follow, their antitrust agencies can fine in a civil case violators up to, say, 10% usually of their worldwide annual turnover. So Sanders and Klobuchar and Warren each had proposals that would introduce something like that. The details were all over the place. Also, there's a big issue. The FTC has the power to make rules, and they use that power extensively in consumer protection. They really haven't used it extensively in the antitrust space. And again, many of the proposals related to more explicitly directing them, the FTC, to issue rules that would flesh out when, well, different things. For example, there's a proposal for the FTC to issue a rule banning certain kinds of no poaching and non-compete agreements in employment contracts as an antitrust issue. There are others as well. So that would expand that authority. Senator Klobuchar had she had a lot of proposals that related to mergers. She also wanted to make institutional changes to make the FTC a more robust enforcer. One of her interesting ideas is the office of a competition advocate that would be within the FTC, where they could not on their own bring cases, but they could do research, do studies, make recommendations, and something that I've seen in other competition agencies around the world. Not shockingly, Senator Warren had some of the broadest and most detailed proposals. She would introduce the concept of a platform utility that would deal with some of the larger tech companies and impose on them duties of fair and non-discriminatory dealings and pricing. She would increase merger enforcement, ban certain considerations of efficiencies. Some of her proposals would also go as far as introduce ideas of abuse of a dominant position, which is how the EU and other countries talk about single firm conduct. We talk about monopolization, and we don't bring a lot of these suits. There hasn't been a major monopolization case brought by the government really since Microsoft. There have been others that have nibbled on the edges. But as most people know, the EU has brought abuse of dominance cases in Microsoft that went beyond what we did, in Google and Intel and Broadcom and Qualcomm and certain other cases. So some of those proposals that Senator Warren had would have introduced some of those concepts into the U.S. So that's on the campaign side, and on the Republican, on the GOP side, it was Trump has just made statements over the years that there's something going on, and has made certain statements about the power of big pharma and the power of big tech, and there really hasn't been any substantive proposals nor any policy to make major changes in the antitrust law by the administration so far.
I guess that going into what Congress is going past sort of just the proposals we saw on the campaign trails and sort of the ideas that were less fleshed out and sort of more of sort of just, talking points, we're now seeing hearings, and I think we heard new hearings were announced today by the Senate, although I don't believe that was general, but we saw hearings on antitrust. And can you tell us what's Congress has been up to and what's their work and how have the hearings been going?
Yeah, so the leading effort is being done in the House Judiciary Subcommittee on antitrust, and it's chaired by David Cicilline, who's from Rhode Island, and he's really been tasked by Democratic leadership to become an antitrust expert. He really has done a fantastic job. His subcommittee has a very substantial expert staff and is well-resourced and has been held hearings and subpoenaed just millions and millions of documents. I should point out I'm one of a number of academics who they have spoken with and asked for our views on various things. I've submitted, along with many other people on both the left and the right, have made written submissions to them as to recommendations about what they should do. And then they've held these high-profile hearings with big tech CEOs. And in fact, they had some additional hearings, I think earlier this week, with more general witnesses about recommendations. So they're getting close to issuing a report. And that report is likely to be accompanied by some draft legislation. Chairman Cicilline had originally said he wanted to issue that report by the end of September. Obviously, we're at the beginning of October now, but I would certainly expect something before the end of this Congress. Now, obviously, the election cycle will cause a new Congress to get rolling. So whether or not the draft legislation will be introduced in this session or held for the new session that starts in January, I'm not privy to that. I do know that the House investigation is, they're in contact with the Democratic leaders who care about these issues on the Senate side. That includes Senator Warren, Senator Klobuchar. Senator Klobuchar has introduced a number of bills, 3 or 4, that relate to merger enforcement and institutional change in the FTC on the kind of thing that I was summarizing before. And I do know that Senator Warren was preparing legislation. Early drafts had gotten leaked to the press in the fall. Far as I can tell, that's on hold for the time being, both first for the election cycle and then because of COVID. So I expect some companion bills in the Senate that will mirror whatever the legislation is in the House. But right now, the House of Representatives is driving that train. There are other bills pending dealing with agribusiness that I kind of talked about that Cory Booker has introduced. And there are a lot of bills that would deal with different aspects of big pharma. And it's entirely possible at the end of the day, I have no illusions of that very much is going to happen if it remains a Republican Senate and a Democratic House. But even if it remains split, there's a chance that some of these pharma bills will go through because of just the political importance of drug pricing, collusion that's going on, both between branded and generic pharma makers. And also there's just some straight up horizontal price fixing that appears to be going on in the generic pharma space that is being prosecuted. So this is a big deal. It's certainly possible that administration would get the green light from McConnell if he's still the majority leader, after January.
And I guess what would the pharma bills do?
The pharma bills that I've seen that I would guess have the best chance of passing clarify and kind of endorse the Supreme Court's activist case from a few years ago that said that these agreements to keep generic drugs off the market can be illegal. And I think these bills that I've seen would just make it a little bit clearer and empower the agencies to go after it, and in some cases also issue some direct fines for doing that. So that's an area that I think it's possible there could be some bipartisan love on.
So turning now to the administration, I think we touched on this a little bit throughout, but continue with it. What has been the administration's approach to antitrust?
Well, separate. Now I'm talking about what political leaders are doing. I'm not talking about the day-to-day work of the antitrust division and the FTC. They're looking at cases, they're bringing cases, they're declining certain cases. But what does the president say about antitrust? Like everything else, he sometimes tweets about it, and he sometimes talks about it. There's not too much that is a through line that you can connect the dots, but he talks about there's something going on about big tech. He occasionally rails about big pharma. And then, the more serious stuff, the economic report of the president that was issued in February, right before the shutdown, basically said that, the agencies have all the powers they need and they're well equipped to handle anything that comes up. The bigger issue has been comments and news items that suggest there are communications between the White House and the enforcement agencies about what to do on specific cases. So there's a tradition that's being blown up in areas outside of antitrust, but there's a tradition that the Justice Department, by and large, is fairly independent from the White House in deciding what cases to bring. And that tradition has been particularly strong in the antitrust area. It doesn't mean that there's nothing wrong with the heads of the antitrust division or the FTC telling the government, telling the White House what's going on with publicly available information. But the biggest concern is that the statements coming from Trump or his known views about firms and people that he regards as, his political foes are influencing decisions both to bring cases and not to bring cases. So there was a lot in the press that there was pressure from the White House, and I have no inside information about this one way or another. But I'm concerned if it's true that an important factor in the Justice Department eventually bringing the AT&T Time Warner case, challenging it, was that Trump's dislike of CNN, which was part of Time Warner before the merger went through. And my concern is not that the case was frivolous. I think it had some merit. I think it's unusual because, without getting in the weeds, it was based on a theory challenging a vertical merger that has rarely been litigated in court by either Democratic or Republican administrations. There were similar concerns that the T-Mobile Sprint merger, the compromise, the settlement was approved, again, containing unusually odd provisions after extensive lobbying by the companies, but also extensive lobbying by and kind of almost deal making by the head of the antitrust division in a way that usually the parties bring the proposed settlement to the government, not have the government out there brokering a settlement in the marketplace. This merger was allowed because some assets are being divested by T-Mobile and Sprint to Dish Network to sort of try to preserve some competition in the cell phone space after the merger. And Dish Network isn't in the cell phone business, and it's it's a possible creative solution. It's also really risky, and it's just kind of odd to have the head of the antitrust division beating the drum to get this and lobbying congressmen and telling them what a great deal this is. You have cases pending against Google, where the administration has made clear they regard there being a lot of political bias in the tech sector. You've got investigations of Amazon going on. Again, don't know what the final outcome will be. Where Trump has been, quite vocal in terms of his dislike of Jeff Bezos, who's the owner of, obviously, of Amazon, principal shareholder of Amazon, as well as the head of the Washington Post. So, what we're talking about is, I'm not talking about flat out corruption. We have plenty of instances of that. There were illegal campaign contributions to the Nixon administration that were a minor part of Watergate that were designed to influence merger decisions of the Justice Department. That's just illegal. That's bribery. Johnson did something similar. He tried to strong arm a bank, just in phone conversations, to get the bank in Houston that had a merger pending before the Justice Department. He was on the phone on tape telling the chairman of that bank that unless he got the Houston Chronicle to endorse Johnson, the merger was going to be blocked. I'm not talking about that kind of stuff. I'm talking about the really complicated, issue of what do you do when flat out political animus is entering the calculation and influencing thin or decent cases, but really putting a thumb on the scale to bring or refrain depending on whether you're talking about a friend or a foe.
So I guess one question is sort of historic. Have we seen this before historically? I think your article discussed some examples of where at least there was decisions about not to go after mergers because there were other political concerns. Can you address that some?
This is just like so many other issues. Antitrust isn't even the lead issue on this. This feels different. Again, a lot depends on what the actual facts are. For example, AT&T Time Warner tried to get discovery to get communications between the White House and DOJ to find out about the political implications, if any. They were arguing selective prosecution. They didn't win. In essence, the judge says, you don't have enough proof for me to give you discovery. Now that's the chicken and the egg problem, because how could they get at private conversations, until they had some discovery on it. So they certainly raised that issue. The court just said, we need more than your suspicion that this is going on. I would contrast this with, we've always had legitimate conversations whether there are other national policies that are more important than antitrust. So for example, the Johnson administration brought the case to break up AT&T in 1969 as they were essentially leaving office, late 1968, early 1969. That case continued through the Nixon administration, the Ford administration, and then there was a settlement that broke up the Bell system in the Reagan administration. There was furious lobbying going on whether or not the company did or didn't violate the antitrust laws, and then whether breaking them up or even going after them was in our national interest because of the effect on defense and communications and other things. And that's not what I'm talking about. That's not political animus. That's a debate whether some antitrust action that is legit on antitrust grounds is nonetheless so harmful to our country in some other way that something should be changed. And you can have an opinion about that, but there's nothing wrong about that conversation taking place. Similarly, you go back a little bit earlier, President Truman changed and directed the Justice Department not to bring criminal cases against international oil companies at the height of the Cold War, because it was feared that it would affect American diplomacy and containment of the Soviet Union, and directed that a civil case be brought. And again, debatable as a matter of antitrust grounds, debatable as a matter of national interest, but there's nothing politically animus based about that. These conversations that you and I are talking about that are hitting the press appear different. The other one that I left out is the reporting that the Justice Department has issued a tremendous number of second requests, which are subpoenas in a merger investigation, very burdensome second requests to deals where cannabis companies are merging, legal cannabis companies are merging, where there's, the industry is very unconcentrated. If these were hardware stores, nobody would raise an eye. And the feeling is that Barr and or the White House have a personal dislike of the industry. It's speculation, but it's odd. It's just not something that, it's weird that something like 29 out of 35 of the recent second requests have all been in these deals that you'd think, even if they're minor antitrust concerns, that the DOJ and the FTC have bigger fish to fry. So again, I'm seeing and I'm worried about the tools that we have to deal with these mixed decisions of some antitrust merit and some political animus. And we have some tools, but they're kind of limited. We just haven't had to have many of these types of conversations before.
So one thing to make clear right now is the difference between the DOJ and the FTC enforcements. We have two different, for those who don't know, we have two different agencies that are tasked with enforcing antitrust law. Have we seen the same concerns come out from both the FTC and DOJ, or has this been, you've been talking mostly AT&T, Time Warner, T-Mobile, Sprint, were all DOJ cases. Have we seen similar concerns come from the FTC?
Yes, but not as many, and not at this level of concern. There's some institutional reasons why this is not surprising. Obviously, DOJ is part of the executive branch, part of the Justice Department. There's more direct communications between DOJ and the White House on legitimate and potentially illegitimate topics. The FTC is an independent agency, 5 commissioners who are, appointed by the president. Only 3 can be of the president's party at any one time. And again, so some structural independence, there are cases pending in front of the Supreme Court that could really blow that up, but we can save that for another discussion if your members want to talk about that as well. But again, there have been reports of some communications between the chairman and the White House about cases. The FTC and the DOJ share civil antitrust enforcement, largely on an industry by industry basis, is what industries each agency sort of has the most expertise in on average. DOJ does all the criminal stuff. And so far, I haven't seen any serious concerns. Criminal price fixing cases are largely apolitical, and that has not yet been a concern in anything that I've seen in the public discussion.
I wanted to get that background before we just ask the next logical question, is sort of how do we stop Animus from entering the calculation?
Yeah. So there's some, one is just naming and shaming. It's right for the press and competitors to call out these things when they see it. Another is, well, first of all, so naming and shaming, continuing to have multiple actors in the antitrust space. And fortunately, the US system is very decentralized, so that in addition to the Justice Department and the FTC, we have 50 state attorneys general who are have each their own little antitrust bureaus, depending on how much resources they have. So like New York and California have very large, 20 or more lawyers and economists. Illinois has 5 or so, and some states just have like one person who has to do antitrust and consumer protection. And the reason the states are an important player is they work together in coalitions through the National Association of Attorneys General. So virtually all the states are investigating Facebook, they're investigating Google, and some combination of investigating Amazon and the others as well in the tech space. And so they have the ability under federal law and under their own state antitrust laws to bring these cases regardless of what the Justice Department does. So you saw a little bit of that in the Microsoft case, where they work together with the Justice Department, sometimes pulling all in the same direction, sometimes a little bit at odds with their co-plaintiffs. And in the end, the Justice Department was willing to settle that case, and the states pushed for a little bit more vigorous terms of that settlement. So you have private enforcement. The problem is in the monopoly area, you can sue for damages, you can sue for injunctions, but if there's going to be any fundamental divestiture or changing the structure of a company or an industry, that's going to have to come from the government. I don't really see realistically a court granting that kind of sweeping relief beyond an injunction to stop doing something illegal in a private case, or they would award damages. So, we need the federal government to bring the big cases, but we have other players, and that makes us a more stable system that you can't yank too far in one direction or another. And then, we have some tools in civil procedure and other areas of the law that deal with this question of political animus. We have, those of you who are involved in litigation, and any of the students on the call, if you've gotten to Rule 11 in the Federal Rules of Civil Procedure, it requires civil plaintiffs, that would include the government, to do a reasonable investigation before they bring a case, and to certify in writing that the case has merit in law and in fact, and is not being brought for an improper purpose. And there are discretionary sanctions involved. That's one way of doing things. There's similar rules in the state rules of professional responsibility that talk about not bringing cases to harass someone. There are internal manuals and guidelines of the Justice Department that prohibit political considerations from being playing a role. However, they're just kind of advisory, and obviously if you're concerned that the agencies are acting improperly, their own internal guidelines are rarely going to stop them from doing so. There are other areas of the law that we can think about. And I'm interested in your questions and your suggestions, because I'm continuing to write about these topics. Tort law has both malicious prosecution, that in essence requires a frivolous case to be brought, to be able to sue somebody. But it also has the tort of abusive process, where you're not arguing that the case is meritless, you're arguing that it's being brought for an improper purpose. So we have employment discrimination laws where very often the plaintiff is saying, you fired me for a discriminatory purpose. And the defendants are saying, no, we didn't. We fired you because you were a lousy employee. And then there are rules and burdens of proof for figuring out which of the two is the more likely or the dominant motive. What we don't have, John, we don't have good tools for controlling government agencies when they refrain from bringing an action, whether it's to reward a political friend or for some other reason if they've made a mistake. The decision of the FTC or DOJ to not bring a case is not reviewable in court. It's not there's no one who has the standing essentially to appeal that. Now, in other countries, we can think about this, but this requires major legislation that I haven't seen yet. In other countries, when you complain to a government agency like the European Commission Competition Directorate, if you're a competitor and you're concerned about Google or something, file a complaint. That triggers the need for the agency to reply with an official decision of some kind. They could say, no violation. or they could bring a case, obviously, or they could say, for reasons of administrative resources, we're prioritizing something else. But when they do, people who are affected, whether they are the complainants or others in the industry, have the ability to appeal that. The agency is given a lot of deference. However, you do have a route to an independent judge to at least look at that. And that's something I think we should think about.
I guess one question, I guess, if you can give us some background, I guess one time we did see a judge review a divestiture non-prosecution was the CVS case. Can you tell us some about that? That was
Sorry, I just didn't hear what you said, John. You popped out for a second.
Oh, sorry. The CVS case, we actually had a federal judge during this administration review a decision not to prosecute a vertical merger, essentially. Can you give some background on that one and what happened there?
You're more expert on that specific one than I am, but it's a very rare occurrence there. And if you go back far enough, there are even a couple of cases that have challenged a governmental CID, civil investigative demands, where they thought they were being issued for a political purpose. But the judiciary is not eager to jump into that pool under the current legislative framework. And you see that also in the area of consent decrees, where the Tunney Act from the 70s, one of the fallouts, one of the good things that came out of Watergate was this idea that you can't settle antitrust cases once you bring them. You can't just do a laydown. You have to show a judge that it's in the public interest. However, Microsoft, one of the decisions, said that the court does not have the power to look behind the complaint that was filed and the settlement that was reached to say, gee, you really should have brought more. So, there's limited ways for the judiciary to make that kind of call. Although, in fairness, I'm not expert on the specific one that you talked about.
Fair enough. Just a reminder that if anyone has any questions, please submit them. I'll be looking at them and asking them as they come relevant. But moving on to our next slide once I get that up. But I guess now's the time sort of to ask, is this, I guess we've talked some about this, but how much of this is a return of old issues and how much of this is sort of new? This, I guess, starting with the saliency.
Yeah, it's been a long time. It's been nearly 100 years since antitrust has been on the political radar the way it is. A little bit in the 1940s, Thurman Arnold was a brilliant spokesman and kind of PR genius. In addition to being a very smart and very dedicated antitrust enforcer, he did a lot of radio talks and kind of things that are you wouldn't ever see. They're good, smart people. Macon Delrahim is the head of the antitrust division, and Joe Simons is the chair of the FTC right now. You wouldn't see them on a national radio broadcast. It's just, you wouldn't see them on the equivalent of Face the Nation. That's not what we're doing today. But back then in the 40s, Arnold had access to radio programs and newspaper columns, in the Washington Post and the Wall Street Journal and those sorts of things, rather than, let's say, a law review article, or something, or a speech to a trade association or bar group. So the fact that, a big chunk of the Warren campaign and a big chunk of her work on the Senate side, not as a candidate, has been to highlight issues of economic inequality. This feels different again. And I think regardless of the outcome of the election, these issues are not going to go away. And I'm no expert on COVID, but I mean, to the extent that you're concerned about issues of misuse of power and economic inequality, they seem to have been exacerbated rather than leveled out by what we're going through on the pandemic side.
I guess getting your concern about Animus, the question we have framed up on our PowerPoint is sort of, what if you do the right thing for the wrong reason? What is the outcome? What is the proper response there?
Yeah, again, some of the state investigations onto the tech giants were started by Republicans. The guy is now senator from Missouri, Josh Hawley, was Attorney General of Missouri. He started bringing, I don't remember if it was Google or Amazon, but he started bringing a state case before the feds were deeply involved in this. There's also possibility of states bringing cases alone, and you could see a world where coalitions of Republican attorney generals are bringing one type of case or seeking one kind of remedy, and conceivably coalitions of the Democratic AGs on the state level bringing different cases or, again, different theories. In the past, the coalitions have been largely bipartisan. There are 48 states investigating Facebook last I looked. So, I mean, that's virtually everybody. That includes the full mix of Republicans and Democrats. So, I'd like to see a world where the predominant criteria is, has there been a serious antitrust violation, worthy of the investment of the kind of resources it takes to litigate the case to conclusion. I think before you bring a case, you should also have a good idea of what the remedy that you want is. And again, like I said, I'm not talking about issues of corruption. We have laws that deal with that. And I'm not talking about issues of public policy, because I think that's okay. And that's, I think, why we have a government. Nobody wants us to bring a valid antitrust case if it would start World War III. That would be idiotic. But mixed motive is a really hard question. And I've outlined to you a few ways that I've, think we can do better. But there's no silver bullet that I've been able to find. And I think we're going to have to deal with the world as we become more polarized politically, where these issues are going to come up. And I think they're going to come up in Democratic as well as Republican administrations. And so I'm not anxious to give well-heeled defendants another bite at the apple to say, not only am I not a monopolist, I'm on the wrong side of the White House, and you should give me a pass card for that. I don't think that's a great world either. But I'm much more concerned for firms that have less power and are on the wrong side of the political equation, of a state attorney general, of a White House, of a Justice Department, or of a foreign government, frankly. I don't like laws that have a neutral political purpose on their face being misused, but it's an issue that goes way beyond antitrust. And so I've talked about kind of the good side of the political salience of antitrust in one paper that's on SSRN. It's on the back slide, which we can make the slides available too, John, for anybody who cares. That's the political face of antitrust, and I address these other markers, side of antitrust in a separate paper, also with Jacob Morris, called The Political Misuse of Antitrust, and that's on SSRN and also the website of Competition Policy International. But it's a real issue, and I at the moment want to air it out and continue to think about the combination of things that will limit it, but I don't think it's ever going to take it off the table.
Have we seen, one follow-up here is, have we seen any proposals from Congress to deal with this issue, or are we talking just about the investigation here?
I haven't seen any proposals in Congress to deal with this. And, at the end of the day, the closest I've seen are proposals that will continue to protect and strengthen private enforcement of the antitrust laws. Because if you think the government's doing a laydown for the right reasons or the wrong reasons, but if you as a business or person are being injured by something, at least the private enforcement and that history is a way to bring the case to court, regardless of what the White House thinks or the agencies think is the right answer. I'm also seeing a little more meddling of the agencies in filing amicus briefs in private litigation, trying to say this theory isn't working, this theory isn't right, this person shouldn't bring the case. And I don't like that. And I'll tell you, the thing that drives me crazy is the FTC brought a politically courageous case against Qualcomm. And the Justice Department, for the first time that I've ever seen, is filing amicus briefs telling the court to throw the case out, which the Ninth Circuit, I believe it is, Second Circuit, I can't remember, has in fact bought the Justice Department's view of a case brought by the FTC. And nobody in the antitrust world wants mom and dad fighting, and there's some feeling that that it's affecting interagency contacts and communications, as well as the cases that DOJ is bringing or not bringing on its own. So we're in for a bumpy ride.
One question that the audience is, the HSR power gives DOJ the ability to sort of drive up costs before even a merger suit is filed, before a complaint is filed. is there any way to effectively block DOJ from using the HSR and investigative tools for improvement?
Yeah, it's really hard. Like I said, there's a couple of lower court cases from literally the 30s and 40s that have raised the issue that the court may be able to block a CID, which is the government pre-complaint subpoena. Under Hart-Scott-Rodino, companies have to file for government review of their merger if they're above a certain threshold in size, basically. It's indexed for inflation. It's around $300-some million. So they get a few thousand filings a year. They have some process that divvy them up between the FTC and DOJ. But the question, it's a good one. Sometimes the mere issuance of a second request, the big lengthy subpoena beyond what you have to file with the HSR filing. Sometimes filing a second request is enough to kill a deal. And sometimes that's good. That's exactly what you want. The firms think it's going to somehow fly below the radar of the agencies, and when it gets their attention and there's a serious risk, the companies back down or negotiate a consent decree that they spin off something or make some other changes. So that's part of the process. And if it's more than just this, marijuana mergers, I think it's something we have to take a look at. I haven't seen a specific proposal. And as I mentioned, John, in AT&T Time Warner, the company certainly tried to raise that in their negotiations with the government, and in litigation, but didn't get very far.
So I guess we're almost out of time here. So I just wanted to give you the chance to sort of, do you have any concluding thoughts you'd like to give us?
Well, a couple things. I think the biggest power, a lot of this is really under the category, John, of discretionary justice. Bureaucrats have to have discretion. Enforcers have to have some discretion. We're talking really, around the issue of how do you curb discretion that's being used for bad things rather than for good things. And so that's an issue that, we have administrative law, but it doesn't answer. 90% of the power of any bureaucrat anywhere in the government is the power to say no. And we haven't done a very good job. Kenneth Culp Davis wrote about this going back into the 60s. He had proposals that are worth looking at again. But the best I can think of, how you prevent the government from just saying, we don't care what you do if you're our friend, and we're going to slam you, even if it's thin case if you're our enemy, is a system of all cases that are declined should have a statement of reasons. We should seriously explore allowing people to appeal negative decisions. We should rigorously enforce Rule 11 and maybe consider not having it be purely discretionary on the federal judge. There should be prompt bar petitions when even government enforcers sign off on things that appear improper and have substantial bad motives. Those are the things we have, and I'm open to any other good suggestions that people can think of from other areas, because mixed motives are part of things that go way beyond our concerns as antitrust lawyers.
All right. Thank you, Professor Waller, for your time. Thank you, everyone, for attending, and that was a great conversation. And we look forward to having more conversations about antitrust and more conversations about the law in general and the politicization. Thank you, everyone.
Thanks, John. Thank you, everybody.